Hear ye. Court of Appeals, of course, we now in session. So we're going to say the Constitution and this honorable court.
Please be seated. Welcome to the First Court of Appeals. We have 4 original proceedings on the docket this afternoon. They are 0124000651CV in Re DELORIS Jones individually and as representative of the estate of Willie Lee Jones Jr. 0124000652CV in Re Wanda Brown individually and as representative of the estate of James Edward Brown. 0124000653CV in Ray Russell Morris individually and as representative of the estate of Clarence James Morris, and 0124000654CV in Ray VELMA Duncan individually and as representative of the estate of Howard MOTEN Sr. Starting with relators, can you please make your announcements?
Yes, Your Honor, FREDRICKSON on behalf of the relators.
Okay, thank you very much. Real parties in interest?
Yes, Your Honor, Robert GILBREATH for Real Party Nationwide.
CAWOOD-ANDERSON for the Real Party Massachusetts Bay.
Thank you. Does relator wish to reserve time for rebuttal?
Yes, Your Honor, 4 minutes for rebuttal.
Okay. And I understand that the real parties in interest, Mr. GILBREATH, you'll be arguing for both parties or all parties?
Yes, that's our intention, Your Honor, unless the court has any specific questions that are specific to Ms. CAWOOD-ANDERSON's claim, Massachusetts Bay.
Okay.
In that event, but I'm not anticipating that. But
okay, very well. But before we begin, you guys know the drill. You'll have the time clock in front of you. If the light turns yellow, that means you have 1 minute left in your time. If the light turns red, of course, that means for you to stop. If you're in the middle of answering a question, please feel free to finish your answer. We have read the briefs and we are familiar with the facts of this case, so you do not need to start with a recitation of the facts. I think it would be most helpful to us if you start straight with the legal issues that we have to analyze and decide today. Relator, when you're ready.
Yes, Your Honor.
May it please the court. My name is Anna Fredrickson and I'm here on behalf of the relators. This case turns on one simple question. Can the MDL court properly exercise jurisdiction over the plaintiff's cases? The legislature says no. Through section 900108, the legislature has chosen to enact specific statutory carve-outs to the MDL court's jurisdiction. This court recognized these carve-outs in its prior opinion in Massachusetts Bay when it said that nothing in the court's opinion would prevent the plaintiffs from seeking remand under subsection A3 again if they could establish the required elements. The defendants chide the plaintiffs for relying on this footnote in support of their motion to remand, but this court's prior opinion is not only the law of the case, it is entirely consistent with the legislature's unambiguous intent to exempt pre-2003 cases from the MDL court's jurisdiction if there is a malignancy diagnosis. The plaintiffs have now served the required reports to establish their malignancy diagnosis. Importantly, defendants do not challenge whether these reports comply with section 9003.
Was that issue litigated at all? Because that is a question that we had. Was there any dispute as to whether the reports were compliant?
No, Your Honor. When the plaintiffs served their initial motion to remand after this case in August of 2020, the defendants did object to the sufficiency and adequacy of the 9003 reports. The plaintiffs then agreed to modify the reports and make them individualized for each of the plaintiffs. After that, the plaintiffs served revised reports, individual as to each plaintiff, in 2021 and 2022. Importantly, Nationwide, in its response to the plaintiff's latest motion to remand, that is the subject of this mandamus proceeding, stated on page 4 that the reports were compliant, but they were untimely. That is on page 4 of Nationwide's response to the motion to remand. Massachusetts Bay Insurance Company joined that response as reflected in the supplemental mandamus record.
Does the MDL trial court have to make that determination regardless of whether the real parties in interest agree to the compliance of the report? In other words, does the statute require independent review by the trial court as to whether the report is compliant?
No, Your Honor, there is not an independent review required by the MDL court. Section 90.010A states that the MDL rules shall apply to all asbestos cases unless one of 3 exceptions is met. Under subsection A3, the MDL rules will not apply if the case is a pre-2003 case and there's the malignancy diagnosis. There was initially some confusion in how to establish the malignancy diagnosis, and this court's prior opinion resolved that the plaintiffs needed to serve a report compliant with 90.003. The plaintiffs have done so, and their reports conclusively comply with 90.003. They were served by a board-certified physician in occupational medicine. The physician found as to each individual plaintiff that they had developed the requisite malignant mesothelioma and that this was caused by exposure to asbestos. That issue is conclusively established in the record, and defendants had an opportunity to object and chose not to do so.
Counsel, I'm curious why it took so long for these reports to be filed in the first place.
Yes, Your Honor, there was a series of delays because of procedural issues with the MDL proceeding, is my understanding. So after this court's remand of the case, the parties initially served an expert report that was as to all of the plaintiffs. The defendants objected to that. At the same time, while this is outside the scope of the mandamus record, what was going on is that the parties were also debating whether or not to sever out all of the approximately 1,200 cases into individual cases. But that created an administrative nightmare with the clerk's office because the clerk's office was only able to sever out through a numbering of ZZ, which was 52 numbers, and there's over 1,200. And so it took some time for the parties to figure out which cases were going to be severed out first and how that would go. And then it took some time also to coordinate with all of the plaintiffs to get their requisite reports.
So are you saying that it's not just limited to these 4, this is kind of a test group, and determining what happens here, there's going to be other people filing, trying to get a remand under A3?
Yes, Your Honor, to the extent that any of those cases were filed before September 1st, 2003, and they can establish the requisite malignancy diagnosis, they are exempt from the MDL rules under the plain language of section.
Do you believe, is there a time frame on when that diagnosis of mesothelioma has to occur? Does that diagnosis have to have occurred before September 1st, 2003, in your opinion?
No, Your Honor. Under the plain language, it simply states that under subsection A3, that if the case is filed before September 1st, 2003, it's restricted just to whether or not the case was filed before September 1st, 2003.
But we can't read that provision in a vacuum, right? If we look at the beginning section of 90.010, the law has just been implemented, it's 2005, and they're saying the MDL rules are going to apply unless 1 through 3 things occur, 1, 2, or 3. Isn't there like a time constraint that we have to look at the cases as they existed in 2005? In other words, if in 2005 there was a diagnosed malignancy, then those cases would not be transferred to the MDL court. But those that were not diagnosed at that time could be transferred. In other words, there is a time component. You can't have a case transferred under either 1 or 2, and then 15 years, 10 years down the road, now establish a malignancy and say somehow that snaps that case out of the provisions of the MDL court. How do we stop, in other words, these cases are being transferred for the purpose of efficiencies. How do we stop now everybody from coming up with a diagnosis, filing the report, and these cases now get remanded back to the trial court?
Because, Your Honor, under the plain language, the legislature has chosen to exempt any malignancy cases if they were filed before September 1st, 2003. The legislature knew how to impose time restrictions in section 900108. It did so for A1 and A2. A1 imposes a time restriction regarding a 90-day window for nearness of the trial date. A2 imposes a time restriction regarding the service of expert reports. A3 does not impose any time restriction at all. Where the legislature has employed terms in one portion of the statute but has excluded them from another portion of the statute, a court should not interpret the statute to have words where they've been intentionally omitted. As the Texas Supreme Court recognized in Lade law, when there were restrictions for annexations for type A or type B municipalities, but those same restrictions did not apply to type A municipalities, the Texas Supreme Court found that it was error to interpret the restrictions for type B to also apply to type A. Here, the legislature has chosen to provide 3 independent exemptions from the MDL rules. We know that they are independent because they are separated by the term or. The legislature states that the MDL rules will apply to A1, A2, or A3.
So the only limitation on A3 is that it would apply to cases filed pre-September 1, 2003, regardless of whether there's a diagnosis at that time or later.
Yes, Your Honor, and that makes sense in light of the exemption's purpose. The plaintiffs could develop their malignancies at various times, and the MDL rules recognize this, that at various times the parties were going to become symptomatic and potentially develop their malignancy diagnoses. And so the legislature has reflected an intent for anyone who develops a malignancy and their case was also filed before September 1st, 2003, that those category of cases would be exempt from the MDL rules.
Is that our case, though? Do we need to reach that? Because I believe, looking at your expert reports in this case, all 4 of the plaintiffs before us had a diagnosis of malignancy before September 1st, 2003. So aren't we really just looking at, in our specific case, if those diagnoses occurred before 2003? We don't need to reach an issue of whether this would apply to someone whose malignancy wasn't diagnosed until after 2003.
No, Your Honor, the court is not required to issue a broad holding in this case. For these specific plaintiffs, the issue is whether they have established their exemption from the MDL rules under A3. All 4 of these plaintiffs have conclusively established their entitlement to be exempt from the MDL rules. As this court recognized in its prior opinion in footnote 9, this is clearly a pre-September 1st, 2003 case. So the first element is satisfied. Indeed, Nationwide, when it transferred this case to the MDL court, took the position that this was a pre-September 1st, 2003 case. Similarly, Massachusetts Bay Insurance Company, in briefing to this court in the prior appeal, stated that this was clearly a pre-September 1st, 2003 case.
How would you explain then, if we agree with you, then we are going to have cases that are similar in nature where there is a diagnosis being treated differently. In one case, you have malignancy cases that are pre-2003 that are being remanded for individual trials, whereas malignancy cases post-2003 remain in the MDL court subject to the provisions of subsection C. Why should we construe the statute as treating both of these scenarios or cases differently? Other than my original question, we were just looking in 2005 to determine which cases would be transferred. But once we're past that point, it seems to me that we need to construe the statute in a way that the same type of cases are treated similarly. My question may be confusing, but what I'm trying to say is, once somebody is diagnosed with a malignancy, whether they were diagnosed pre or post 2003, you're asking us to construe the statute in a way that these cases would be treated differently under the statute. Some would remain in MDL, some would revert back to the trial courts.
That's correct, Your Honor. The legislature in section 900108 has reflected a clear intent to treat those cases differently and to permit them to not be subject to the MDL rules. 900108 states that the MDL rules shall apply to all asbestos cases unless one of 3 exceptions is met. Here, one of the exceptions is met. The legislature in its wisdom has chosen to exempt these cases from the MDL rules. The plain language of section 90-0108 does not afford any discretion to the MDL court to deny a motion to remand if those elements are satisfied.
How would section C apply to the present circumstance? It talks about cases that have been transferred to the MDL court where there has been a diagnosis. It does not require an immediate remand. It requires that those cases remain in the MDL court subject to certain conditions. Why would these cases that we're deciding today not fall within the ambit of subsection C?
Because of the language in subsection A, Your Honor, in which it states that these specific categories of cases will not have the MDL rules apply. Subsection C is contemplating when the MDL rules do apply to those cases. But subsection A is dealing with those categories of cases where the MDL rules do not apply. And so subsection A should be interpreted as it is written. The legislature has reflected its intent to exempt those categories of cases. Now, the defendants have raised 3 general arguments in order to defeat remand, but none of those arguments have any merit. The defendants argue that subsection A3 imposes a time restriction that is not contained in the language of subsection A3. As we know, the legislature knew how to impose a time restriction if it wanted to do so. It did so in A1 regarding trial dates, and it did so in A2 regarding the service of reports. But the legislature omitted any time restriction at all for subsection A3. So it would be improper to impose or imply a time restriction where the legislature has intentionally omitted one.
And below, during the hearing, I believe, tell me if you disagree, Judge Davidson didn't look at the merits of these reports or anything like that. It simply was, because B applies at this point, because the report wasn't filed within 90 days and the transfer was proper under B, A doesn't apply anymore. Was that the substance of his holding?
Yes, I think that generally captures his holding, but this is erroneous for 2 reasons. Subsection B, on its face, is limited to those attempts at remand under subsection A2. Moreover, if this court were to interpret subsection B to apply to all of the avenues of remand under subsection A, it would nullify A1 and A3. And we know that the legislature intended for those to be all independent avenues of remand because they're separated by the term or. You can satisfy A1, A2, or A3. But the MDL court's interpretation of subsection B would erroneously require plaintiffs to always meet the requirements of A2.
Well, to your point that we have to look at the language that is used in the statute. The statute chooses where to use the word remand. And remand is very limited in 2 instances used in the statute. It is not used in reference to A3. It's used in reference to a remand when there is a report that was filed, that was timely, and that it was compliant. But I don't see any use of the word remand as it concerns A3. So is that the proper, should it be dismissal? Should it be a remand? I don't see remand as it concerns A3.
Whether it's remand or dismissal, the MDL rules cannot apply. They have been specifically exempted by the plain language of section 90-010A. So because the plaintiffs have conclusively established both elements of subsection A3, we would respectfully request that this court grant relators petitions for writ of mandamus in order that the trial court remand these cases back to Orange and Jefferson County.
Let me ask you one thing. So one of the arguments the real parties have made is that once a case is transferred to the MDL court pursuant to A2, notwithstanding the potential application of A3 down the road, then we have to follow that track. You're in A2 world, so now B applies. And so my question is not necessarily does B trump A3, but can we construe the statute as once having been transferred to the MDL court under A2, then we're confined by A2 and the provisions that would apply to A2 under subsection B?
No, Your Honor, because that would directly contravene the plain language of section 90-0108 that states that the MDL rules shall apply unless one of 3 independent categories is met. The legislature has specifically exempted certain categories, and subsection A2 is not a vehicle to trump the legislature's unambiguous intent to provide for 3 independent categories to entitle a party to be exempt from the MDL rules.
And you would argue that those 3 exemptions are jurisdictional in nature?
Yes, Your Honor, but even if the court were to find that it's merely a procedural remedy, we believe the outcome should be the same in this case, but we do believe that it is a jurisdictional limitation because it says the MDL rules shall apply unless those 3 exceptions are met.
Couldn't it be that the court had jurisdiction under the rules unless and until the point where you prove A3 applies, and at that point the rules no longer apply? It's not necessarily jurisdictional, but at that point is when the remand or the dismissal or whatever has to occur.
Yes, Your Honor. Even if this court views it as a procedural remedy, the legislature has made clear that those 3 categories of cases will be exempt once it has been established.
And under what circumstances do you interpret subsection D as applying to govern the remand?
Subsection D states that when a case has been transferred to the MDL court and remains pending, the trial court or the MDL court shall not remand, quote, for trial. So subsection D expressly contemplates that the case has been properly transferred to the MDL court and should remain pending there. It is not a prohibition or additional requirement or section 90.010A. Now this court did find that in order to establish the malignancy diagnosis, a plaintiff should do so through a section 90.03 report, but we do not see subsection D as an imposition or restriction on those exemptions in section 90.010A.
And do you dispute that that the case was properly transferred in the first place, given that there was no report at that time?
No, Your Honor, we don't dispute that. What we do dispute is that this falls within subsection A3 and therefore is not properly subject to the MDL rules, and that has now been conclusively established.
So if we adopt your interpretation of A3, how is this not essentially a poison pill that blows up the entire statutory scheme?
Your Honor, the legislature has chosen to limit this to pre-2003 cases, but that is the category of cases that they have chosen to exempt. There's no other language in the statute that justifies contravening this clear exception to the MDL rules.
Any further questions? Thank you, Relator.
Thank you, Your Honor.
Appreciate your argument. How many extra minutes did we use?
3 minutes and 22 seconds.
Okay. We have an additional 3.5 minutes. Mr. Gilbert.
Good afternoon. May it please the court, Robert GILBREATH for the real parties in interest. I'd like to try to, before I begin my canned remarks, which I'm sure you'll get me off of, I'd like to try to answer 3 of the questions that were asked by the panel early on in the argument. The first one was, the question was whether, I think the point was made, no, I think it was a question. The question was whether the real parties in interest concede that the reports are sufficient. And we would agree that the reports comply with the procedural requirements in section 90.003, but we do not concede that the substance of the reports is valid. That's something that we would be able to challenge through limited discovery under Judge Davidson's case management order.
Walk me through that nuance because I'm not following you. So it's compliant procedurally in what way?
Well, with the requirements that are set forth in 90.003, which are, you have to have I think it was a board certified doctor.
Right.
90.003. Yes, board certified physician, so that would be one, and the exposed person has been diagnosed, that would be A, and the doctor said that to a reasonable degree of medical probability it was caused by asbestos, but we don't concede that that's necessarily correct. We just concede that the form of the report.
So in other words, you're conceding that they've complied with the statute. You're just not saying that you're precluded in the future from challenging what those findings stand for.
Correct.
Okay. Great.
Okay, and separately or in addition to that, you don't believe the trial court has to make that independent analysis when the parties agree that the report complies with the procedural requirements of 90.003, that should end the matter.
I would think that Judge Davidson would be free to disagree with the parties. I think he's got a pretty busy docket, so he'd probably accept a concession like that. But I think if he felt, you know, the need to independently review, he could.
And if I can state this differently, let's say this was under D and you guys were all, you had done your discovery and you're ready for trial. You wouldn't be objecting at this time if that report doesn't comply with 90.003. You'd be saying it complies, let's go to trial.
Yes.
Okay.
Justice Johnson, you asked a question about the language of A3, and I think your question was to the effect of did the person have to be diagnosed before September 1, 2003? And because of the present perfect tense of that language, it says has been diagnosed. So yes, the proper construction of A3 is that they had been diagnosed before 9/1/2003. That's, again, the use of the present perfect tense. And there's a couple of cases. There are cases within, by Texas appellate courts. One that comes to mind was from Austin, which I didn't bring with me, but the court said, yeah, this is present perfect tense. And so we have to construe it as something that's already happened. I also found a Justice Blackmun decision from the U.S. Supreme Court saying the same thing. So that would answer that question.
And I'll just be honest, that kind of is what makes statutory sense to me. And in this situation, would you agree that all four of the current relators had their diagnoses before September 1st, 2003?
Well, that comes to your second question. And you asked, and I'll answer it by answering that question. You said, well, they had diagnoses before 2003, and so do we need to reach this issue at all? And the answer is yes, we do, because of the court's holding in the prior Massachusetts Bay decision. There, the court said you got to file, to prove you had a diagnosis, you have to file a compliant Rule 90.003 report. We can't just take it if you had an osteopath issue a report before 2003 that said you had asbestos caused a malignancy. That's not good enough. You got to have a Rule 90.003.
Which you concede we have here. We have a compliant 90.003 report, right? That's what I just heard the party say. At least I see that there is some agreement that there is a 90.003 procedurally compliant report.
Yes, and so then, of course, the question becomes, was it timely filed? Were they timely filed?
And that's a separate question, right?
And my concern is is a floodgates type issue, because if you had to have your malignancy diagnosis before September 1st, 2003, I think that's going to be a much more limited universe than, as long as the case was filed before September 1st, 2003, you can get your malignancy diagnosis at any time in the future ever, and you're going to fall within A3. So, but I think in our situation, all four of the relators had their diagnosis before September 1st, 2003, and that our holding would be, is whatever it is going to be to that universe. It's going to be narrow. We don't have to consider whether or not this statute applies to people that got their diagnosis after September 1st, 2003.
And of course, Your Honor, I'm not an asbestos specialist, and so I'm going to try to reserve some time for Ms. CAWOOD-ANDERSON to, if she can, based on her experience, answer that question. But I mean, we're speculating about the question of, or at least I am, about how many people, because we're talking about potentially hundreds, maybe thousands of people who claim, who filed before September 1, 2003, claim to have a malignancy. And I don't know how many of those would have what they would call a diagnosis. It could be, and she may know from her experience, it could be hundreds, thousands, but I can't answer that because...
But it's certainly going to be more limited if they had to have that diagnosis before September 1st, 2003 than if they were able to get that diagnosis at any time and fall under A3.
Potentially.
But when exactly was the compliant report actually filed?
It was filed in 2020, I had mine in 22.
2022.
So
Okay.
this court said in 2018, Mass Bay said, you guys got to file reports. So those came about 4 years later.
Right.
Mm-hmm. Okay.
Would you agree that subsection A123 are jurisdictional requirements?
Well, I mean, that's one way to state it. I think what I would state is that, let me think about that for a moment. What I would state, since we're focused on A3, is it's jurisdictional in the sense that if you want to get out of the MDL, you had to have a diagnosis, you had to have a claim filed before 9/1/2023, you had to have a diagnosis, which this court has said you prove up through a report, a 90.03 compliant report. And it's our position that report had to be filed within 90 days of the, when the statute, Chapter 90 became effective on September 1, 2005.
Right.
So that's our position. So yes, in that sense, jurisdictional.
And jurisdictional, and how do you respond to the argument that subsection 8.3 is not time limited?
Okay, so that's the main part of my argument. And if you'll permit me to kind of get into my discussion of why we believe the statute should be construed that way. And by way of introduction, recapping their position, it is that the relators and other parties, now years after they've entered into the MDL, can file a Chapter 90 report and use it to prematurely exit the MDL, and we submit that the statute does not allow that. That subsection A3 doesn't provide an open-ended escape hatch. So, and the reason we say that is, well, let's start with the statute's structure. 90.10A sets out 3 exceptions, as you're all well aware, to the rule that asbestos cases go into the coordinated MDL. So A1 and A2 both require something to happen within a strict 90-day window, either commencement of trial or service of a compliant medical report. And that deadline it's not arbitrary. That's the legislature's way. That was the legislature's way of saying, if you want out, speak now. Of course, the relators, as we know from today's argument and from their briefs, they want you to believe that A3 is different, that it gives malignant plaintiffs a right to exit the MDL at any time. But in our view, that interpretation breaks the symmetry of the statute. We say, why would the legislature impose rigid time constraints in the first 2 exceptions, A1 and A2, and then, without saying so, grant an indefinite exemption in the 3rd? It's our position that the legislature wouldn't do that, and it didn't do that. You know, yes, A3 refers specifically to malignancy cases, but the purpose of that was just to make clear that the MDL rules and the statute also apply to those cases, not just to, as you recall, and well, even
why is the inverse not true, though? If the legislature chose to impose time limitations, why wouldn't it be that it chose to not impose any on subsection 8.3? I mean, either could be true, right? Either it's indefinite or it's not, but it could lead to either result.
Well, I mean, I don't mean to be flippant when I say anything could be possible, but I don't think that that's the proper way to read the statute. We're not asking the court to read something into the statute. It's more about reading section 3A in harmony. It's harmonizing, reading 3A in harmony with A1 and A2, which both impose a strict 90-day limit.
Well, to Justice Johnson's point, would it harmonize it for us to construe that subsection A3 precludes any cases where there was a malignancy pre-2003 to ever be transferred to the MDL court versus other cases that have malignancies post-2003? You can read in harmony with the statute, and specifically with respect to subsection C, which addresses cases that have been transferred to the MDL, and then there's a subsequent diagnosis.
Yes. So our position is A3 says if you had a pre-2000, sorry for repeating myself, but filed pre-2023, September 1, 2023, and you had a malignancy diagnosis, which the court has said you got to prove up through a compliant report, and you filed that report within 90 days, then you get out of the MDL.
But that part is not in the statute. That's where I'm having a hard time. It doesn't say, and you file the report. I understand generally that's subsection 8.2.
Right, exactly.
And what you said to me would almost just write A3 out of the statute completely and make it superfluous.
Well, no, I think not, Your Honor, and here's why. Yes, we're asking the court, it's the language 90 days is not in A3, obviously, and I'm not going to deny that, but when you read the statute and harmonize those provisions, and you read A3 not isolated and out of context as they wish the court to do, if you read it in conjunction with the remainder of the statute, you see that there is a 90-day provision. Darn it, I forgot my point I was going to make to you, Your Honor, but the point is that, we're not, why? Why is it there? Okay. So let's think back to when the statute was enacted. This court, as you pointed out in Mass Bay, you said, you quoted from the Enabling Act, and this gets to answers the question about A3. So the court said, the court quoting from the Act, so this is really from the Act, it's the purpose of this Act to protect the right of people with impairing asbestos-related injuries to pursue their claims for compensation in a fair and efficient manner through the Texas court system, while at the same time preventing scarce judicial and litigant resources from being misdirected, etc., by the claims of individuals who have been exposed to asbestos but have no functional physical impairment. All right, so what the legislature was dealing with primarily at the time, and what motivated it, was you have all these asymptomatic plaintiffs filing hundreds and thousands of claims in the courts and clogging them up, and the court really would, the legislature was really focused on those, but it added A3, in my way of looking at this based on this legislative history, it added A3 to say, but we're not limiting it to asymptomatic plaintiffs. We are also applying the MDL rules to malignant plaintiffs, and you got to follow this rule. You got to have it filed before September 1, 2003. You got to file your report, and it's got to be within 90 days. Again, the 90-day rule is not stated there, but it derives naturally from a natural reading of the statute that places everything in harmony and doesn't read A3 out of context and in isolation.
What do we do? I'm sorry, go ahead.
To your point about needing to harmonize the entire statute, I just would like you to walk me through briefly how we could read A3 in harmony with subsection B and subsection D.
Okay. Let's go through the subsection B issue. Let me just grab my notes. As the older I get, I find that I put more things on paper. Okay, so let's talk our way through subsection B. And by way of introduction, my position is it's procedural. It doesn't bestow any rights. So first, B says a defendant may transfer if no report was filed within 90 days after the statute became effective in 2005. Okay, that's number one. 2, it says the MDL court shall remand if a report is filed within 90 days. 3, it says, on the other hand, the case shall stay in the MDL if no report or non-compliant report. So let's look at that in terms of what this court held in the Mass Bay decision. First, the court held that the transfer of these cases to the MDL was proper if there was no report within 90 days, because there was no report in 90 days, even if it involves a malignancy. Well, the court had to read that into the statute by reading it in harmony. The court said, look, the court said, among other things about statutory construction, legislative intent derives from the act as a whole rather than isolated portions of it. So in reaching this conclusion that they had to file a report, the court was doing exactly what I'm inviting the court to do today. And then,
do you agree that the cases were properly transferred under B? I'm sorry, as we said in Adkins?
Yes, I believe they were. Yes, I agree that they were properly transferred to the MDL. Whether it's under, yes, B would be appropriate.
Because it seems in your real parties and interests responses on mandamus, there's some argument there that because your clients weren't brought in until 2017, they don't fall under Chapter 9010 at all.
Oh, yes, exactly, and that's our alternative argument.
But isn't that kind of at odds with what you argued in Adkins?
I don't think so. I think it was an argument that, well, my client wasn't a part of the Mass Bay decision. We didn't do any, we were not a party to that appeal. So, but the position, is I won't spend a lot of time on it because I know you understand it, is they brought these direct actions against us long after 2005. I think it was in 2012. No, that's when it was 2017. So they got these, quote, judgments, what they're calling a judgment against us in 2012, and then brought the action in 2017. So we would say that there's no way any opt-out, the A3 rather, there's no way A3 could apply because these are not September 1, 2003 cases. These actions direct actions against the insurance companies are separate actions, and they, for purposes of the statute, they came about as of 2017, certainly no earlier than 2012 when they got these purported judgments. That answers the question. But and I was saying about the B analysis. First off, this court said, and I said, the court read into the statute that, because they're saying it's an A3 case, and the court said, well, okay, but you still have to file a report, and that's not in the statute, but the court arrived at the conclusion that the statute nonetheless requires it. The court said, in considering Chapter 90 as a whole, particularly its requirement that claimants file a medical report that meets the standards, we conclude that when a case has been transferred pursuant to 9010B for the failure to file a timely medical report, then they got to file a report. So the court read the statute as a whole and read that into the statute that, yes, you got to file a report. They were arguing, no, you don't have to file a report.
Right.
Okay.
Mm-hmm.
So,
so they have to file a report. We have a procedurally compliant report now.
Yes.
And then we also have footnote 10, law of the case by which we're bound. What do we do with that, and what is your response to the fact that in Atkins we held that once that compliant report is filed, the parties can seek remand under A3? That,
Your Honor, was not a holding. It's dicta in a footnote. So the court was just, and I don't mean to use this word disrespectfully, I really don't, but I would say gratuitously making an observation that to that effect. And it's dicta. It's not a holding. It's not binding. And that issue was not before the court. And as you know, as judges, and from my experience, really issues don't really get developed until parties are clashing and fighting over that issue. And that's just like in this case, the battle between the two of us over the proper construction of the statute raises these issues.
But wasn't a motion for remand considered already at that point? Because part of our holding was they needed to file a report to comply with it, not just the medical records they had filed.
Yes. So the parties weren't fighting over the 90-day rule that we say applies to A3. So the court stated that dicta without having really had the parties fight over it and reveal.
Right, so you say the issue is not properly before us, and now it is, and we have to tackle with that.
Yes.
But what I am hearing you say is that you read the Atkins decision to bootstrap the 90-day requirement into A3. And so I worry then, in what circumstances would A3 ever apply?
Would A3 ever apply? Well, yes, it would apply to those parties who, I can't answer the question because I would be speculating, but yes, it served a purpose and it would have applied. You had asbestos lawyers on both sides watching what the legislature was doing, and they knew the statute had been passed and would take effect on September 1, 2005. And so they studied it, lawyers on both sides, and they would have had an opportunity to say, whoa, we've got, for example, these claimants, we've got what we say are diagnoses. We better get reading the statute, we better get a compliant report and file it within 90 days. So yes, it would have been effective as to those plaintiffs or claimants who had cases pending at that time.
But then You see, the problem I have with that is there's an or, there's a disjunctive between 1, 2, and 3.
Right.
And so if a report is always needed, as we stated in Atkins, to establish malignancy, then A3 means nothing at all. We're basically collapsing A2 and A3 together and say to have a malignancy, you need to have a report. You have to have a report within 90 days of the passage of the statute. Otherwise, you're an MDL court.
Right. So, again,
and I know there's no answer. This is why we're here. This is a complicated case.
Yes, it is.
But help us walk through it.
yes, so,
And the example you just gave, to be fair, this isn't a situation where this has been in limbo in an MDL for 20 years. Once they brought you, the insurance companies in 2017, you very quickly removed it to the bankruptcy court, transferred it, and then they very quickly started filing their motions to remand, which they've done straight through. So there's never been really a limbo phase where they were sitting on these malignancies and didn't do anything with them.
yeah, well, there was for, there's a lot of these claims, I have the dates written down somewhere, but these claims were filed in the 90s, I think around, most of them in 1995, so what were they doing for all those years?
Well, nobody removed them or transferred it to the MDL court in 2005 when the statute came out.
Well, they could have been prosecuting those cases in trial court, but nonetheless, I mean, these cases sat moribund for a long time. But back to the question, Your Honor, about the disjunctive, the or. Yes, Section A3 does stand as a separate exception, but and our position is it doesn't stand outside the statutory logic. All three of these define narrow exit routes. And so again, reading the statute as you did in Mass Bay, in context, reading everything in context and in light of the purpose of the statute in Chapter 90, it does require those reports to have been filed within 90 days. And, you know, I don't know why they want to have a DNDL, because you have that subsection C where cases can be expedited. You have Judge Davidson who knows everything. The guy has been on the bench doing the MDL for over 20 years, I think now. He knows how to get these cases moving, how to dispose of the issues. He's way better than anything you're going to get in the trial court for asbestos cases. Only thing I can think of is they've got that crazy argument that these were purported judgments, which we're not going to go into today. But they're thinking Davidson's going to see right through that. So maybe we'll have a better chance outside of his court in arguing that these things that we're calling judgments against the insurance company really are that.
Counsel, I'm curious to get your thoughts as to subsection D and Floor Enterprises, which seems to suggest that remands typically happen under subsection D. How does that fit in to your view of the statutory scheme?
Well, I've given that a lot of thought, and my focus has been more on subsection B, because that's more of what they argued. Let me take a look. I thought you might ask that question because you asked it the other side. And I was trying to look through D again. Let me just do it live while we're here. So D says, an action that was pending on August 31, 2005, and that was transferred. So it applies to a case that had been transferred to the MDL. The court shall not remand for such an action for trial unless a report has been served. So how does that, I mean, I'm not sure how that factors into the analysis today.
If you don't think it applies, that's your answer then.
Well, I may be wrong, Your Honor. It's just, I've been struggling with this statute for a long time, and I'm trying to figure out all these provisions. I'm not sure. I was telling co-counsel, it's kind of like on my family ranch every spring, these little frogs pop up alongside the river, and my kids try to catch them. You think you got a hold of it, and you look in there, and the little guy jumps right out. That's what they're trying to get a handle on the statute is like. So I won't bore you with my stories anymore. But, so we, for all of these reasons, including that alternative basis for affirming Judge Davidson's decision, we ask that the court deny mandamus relief.
Do you have any more questions? Thank you, Mr. Garrett. Ms. CAWOOD-ANDERSON, I want to give you the opportunity in case there were some questions that you feel that you need to clarify for our benefit.
Your Honor.
And we'll go ahead and add some additional time to your rebuttal to address that.
May it please the court. So I wanted to first address Justice Johnson's question, the pre-2003 versus the post-2003 malignancy diagnosis. I don't think it will open the floodgates. I think those that were diagnosed with malignancies pre-2003 filed their lawsuits. They could prove at that time that they had a malignancy.
At what time?
At the time they either filed it or prior to the statute being enacted, but I believe from 1995, when this was originally filed, to 2003, they had a significant amount of time to prove we had a malignancy. And so through that time, they should have done whatever needed to be done at that time that was required to prove the malignancy. Now the post-2005, we have what is required to prove the malignancy. And so I think that's where that difference is. And then
I'm sorry, because I want to make sure I understand what you're saying. I understand what you're saying. There was ample time and they could have done it. And they didn't by the time the statute came into effect in 2005. Nonetheless, here we have, at least the parties here did have malignancies at the time the statute was passed, and these cases were filed post-2003. And so it was just a procedural issue, right? They weren't able to establish that at the time. Since then, Atkins says you need to do it post-removal or transfer through the through the 90.003 report. So are you saying that even those cases where there was some malignancy prior to the passage of the statute, once the statute was passed, those plaintiffs can no longer establish malignancy for purposes of A3?
I don't think they can not establish malignancy per A3. I respectfully disagree with some of the reports that were filed. I don't know if malignancies have been proven. As you said, they have filed compliant 9.003 records, but we have not been able, we've had so many remands and all of this, we have not had a chance to do any limited discovery, which is permitted by the MDL, to verify.
So once again, my question, just to make sure we're clear, is everyone's agreeing that these are compliant reports under 90.003. Of course, the insurance companies here are reserving the right. You're going to do discovery and find out whether or not, there's actual breach and causation here. You're reserving that. But as far as reports go, these satisfy 90.
Correct. We're not arguing that.
And I don't think they're arguing that you're not allowed to ever conduct discovery.
And I would agree with that as well. I did want to address D. So D is very specific. It says that it should remand for trial. So opposing counsel actually did address that. So these cases, they're not litigated at all. There's been no discovery. It's taken almost 20 years to get reports, whether they're substantially compliant or not. It's taken 20 years, so it's remanded now. How many years through Jefferson County and Orange County is it going to take to get through this? If Judge Stevenson can wrap all that up, kind of do some limited discovery, that's going to significantly help the trial court. And so I think D relates to in preparation of trial once we get past the MDL rules in that third version. I believe that's might answer your question. And then Justice Johnson, did you want me to address the 2017 argument that my client made?
I would like to.
Yeah, absolutely. So I understand the confusion. We've conceded that these cases specifically were filed filed in 1995. We agree, they have been, not against my client. So they brought a direct action against my client and Nationwide in 2017. They may argue, which I believe would be the correct argument, that they were put on notice. However, the definition they provided for what the defendant insurance providers are is very broad. I don't think it puts anyone on notice. And my client, Moore Hadley, who we insured, went into bankruptcy. The bankruptcy was finalized and closed. Well, then we have the plaintiffs that came in 2012 that requested the bankruptcy court to elaborate on their ruling because they wanted to collect money from us. And so they claimed that the 2012 is a judgment for them. 2012 is going to be the first time my client and Nationwide was put on notice at all. And so the distinction is, yes, these cases were filed in 1993 against other defendants, not including my client. The Supreme Court has said that when a new party is added, pleadings are adjusted, new parties are added, that they do not relate back to the original pleading date unless there's a misnomer or a misidentification. Misnomer does not apply. The misidentification also does not apply for the reason I told you. If you read the definition of what a defendant insurer is, there's no way you can identify my client, couldn't identify Travelers or any of the other insurance companies that were not prior to in the 1995 pleadings.
What about their argument that to differentiate LaFleur when the Adkins case, Massachusetts Bay argued LaFleur doesn't apply because unlike this case where the action was filed before September 1st, 2003, and LaFleur it was afterwards. So they're arguing a judicial estoppel.
And I understand that, and I think clarification needs, when we say these cases, we mean the 463, I believe, plaintiffs who filed their original claim, whether it be early or late 1995. That's what we mean by these cases. We mean the totality of this case that's been going on forever.
So what do you mean when just these 4 plaintiffs?
I'm sorry?
What would you mean then if you were referring to just these 4 plaintiffs like we are on this mandamus?
So just these 4 would be the 4 that you listen. I want to make it clear, I do not represent MOTEN.
Okay.
There is no MBIC claim for MOTEN.
Okay.
I'm just the other 3. Those 3 filed lawsuits specifically against my client and Nationwide. They're specifically listed in their pleadings of who we are. They did not do that until it was already transferred to the MDL. And I believe the first amended petition for at least Plaintiff Brown was filed in 2023, which is when they had already severed these cases and they're doing their 4 quote-unquote test cases to see how these go. We were not specifically listed for just these defendants until 2003. And so when there's a direct action against insurance companies, which I will not address that issue.
For another day.
But when there's a direct action brought, there was no previous direct action brought against us. And so this is a completely new lawsuit, completely new. And so 2017, if you were to accept my argument, then we would not need to argue A or B because E and F would apply because those are post 2005, I believe, as what the language of the statute says. And so that's our distinction.
So to be clear, are you saying that the 4 plaintiffs in this case, I understand that one of them doesn't apply to you, but they did not file the claims against the insurance defendants until after the Adkins case was already, decided and over?
In context, yes, I do. That's what I believe. It is, like as co-counsel said, it is an alternative argument. We have not been able to address that with Judge Davison. We did bring it up in the most recent remand hearing, and Judge Davison specifically said, I also have a question about that. And they did ask my relators, can you explain that? What do you think? And they just fumbled and were not able to answer that question. So we haven't even been able to raise that issue with the trial court. And so whether or not it is pre or post is not, I guess, not for this case because we are arguing A and B, but in the alternative, we should stay in the MDL because my clients were not sued until post. And so E and F would apply, which would keep the cases in the MDL.
Right, but because it is an alternative case that has not been decided in the lower court and has not been raised, we can't consider it here.
And I do agree. We were saving it for appeal. We did just want to bring it to the court's attention. I don't think that we're stopped from raising it,
right,
but I do believe it is an alternative reason to keep us in the MDL.
Thank you so much. We appreciate your
Thank you.
argument. How many minutes? 13. So you have 17 minutes for your rebuttal. You don't have to use it all, but feel free.
Do my best not to, Your Honor.
May it please the court, I have 3 points. First, Justice Johnson, to answer your question, if the court is inclined to construe subsection A3 to only apply to those cases where a diagnosis was before September 1st, all of the plaintiff's cases were diagnosed before September 1st, 2003. That's in the record. So all of the plaintiffs comply with that. Second, to the extent the defendants are now attempting to take the position that this is suddenly a post-2003 case, they have judicially admitted otherwise, and they are prohibited from now taking a contradictory position. Massachusetts Bay Insurance Company participated in the appeal, the prior appeal for this case, and it said unequivocally that in re flor did not apply, and that this court should affirm the MDL court's denial of the plaintiff's motion to remand precisely because this was distinguishable as a pre-2003 case. Massachusetts Bay Insurance Company affirmatively, unambiguously took that position. They have judicially admitted it. Similarly, Nationwide, when it transferred this case to the MDL court, did so under subsection B. Subsection B only applies to pre-2003 cases. So on the one hand, Nationwide got this case into the MDL court on the argument that it was a pre-2003 case. Now they're saying that we can't get out of the MDL because it's suddenly a post-2003 case.
What about counsel's argument that these 3 or 4 plaintiffs relevant to this mandamus weren't suing the insurance companies until after Atkins was already decided, and therefore judicial estoppel wouldn't apply to them? Does that make sense?
Yes, Your Honor. Let me make sure I understand your question, because Massachusetts Bay Insurance Company did participate in the prior appeal. They were involved in
But were
this.
these specific plaintiffs already involved at that point? It's suing the insurance companies at that time?
Yes, this court issued its opinion in 2020. I believe the briefing occurred in 2019. Both Nationwide and Massachusetts Bay Insurance Company were added in 2017. So when they were making these arguments, when Nationwide transferred the case, and when Massachusetts Bay Insurance Company did its briefing to this court, they were parties to this case.
So all 4 of these plaintiffs were already parties to the transferred MDL, and they had already asserted claims against these insurance companies?
Yes, yes. So it's when the plaintiffs added the new defendants in 2017, then Nationwide transferred it under the theory that it was pre-2003. So this, and this court also recognizes in footnote 9 that this is a pre-September 1st, 2003 case. To the extent that defendants would now argue otherwise, they've judicially admitted it, and they are prohibited from doing so.
And is that something that Judge Davidson needs to consider for the first time, on a future hearing?
No, Your Honor, he does not, because the plaintiffs have conclusively met the elements of A3. All they have to establish is first that it's filed before September 1st, 2003. All of the plaintiffs' cases in this case were filed in the 1990s. Second, they have to establish the malignancy diagnosis. That's in the record in their motion to remand. Defendants' interpretation of subsection A3, or defendants' interpretation of the statute, if this court were to adopt it, would write subsection A3 out of existence. Defendants want to talk about every other section of the statute but section 90-0108. 90-0108 states that there are 3 categories of cases that are going to be exempt from the MDL rules. But if this court interprets subsection B to apply to all of the avenues of remand, suddenly someone cannot be exempt from the MDL rules unless they also always comply with A2. But that is not how the legislature structured the 3 exemptions from the MDL court's rules. The legislature said if a plaintiff can satisfy A1, A2, or A3. But under the defendant's interpretation, if this court were to adopt it, subsection B states if a plaintiff fails to satisfy the requirements under A2, then the MDL court shall retain jurisdiction. If that applies to all of the avenues of remand, it would write A1 out of existence, which is in regards to trial dates, and it would write A3 out of existence, because now it's imposing the requirement on A2 of both of those. So the defendant's interpretation is untenable. It does not harmonize the statute. Rather, it contravenes the unambiguous intent to have 3 independent categories of exemptions from the MDL case. So the defendant's interpretation would not harmonize. And as this court recognized in footnote 10 in its prior opinion, the legislature has created these independent avenues of exemption from the MDL rule. That's why this court stated in footnote 10 that nothing in the court's opinion would prevent the plaintiffs from seeking remand again if they could satisfy the elements of A3.
So how do you respond to the argument that is dicta and the issue that we're squarely faced with here was not faced by that separate panel in Atkins?
It is dicta, Your Honor, but it's also the law of the case, and we disagree that that issue was not before the court. The plaintiffs had moved for remand under subsection A3, and this court held that we had failed to establish the malignancy diagnoses by not proving those up in a 90-003 report. The very issue of whether the plaintiffs were entitled to remand under A3 was at issue in this court's prior appeal, and this court nevertheless still stated that the plaintiffs could seek remand again under A3 if they served the required reports. And this court likely did so because that is exactly what the statute says. Subsection A states that the MDL rules shall apply unless that exception is met. Because the exception has now been established, the plaintiffs have served their required reports, the defendants concede that they're procedurally compliant, and this is otherwise a pre-September 1st, 2003 case. Those conditions have been satisfied, and the plaintiffs are now exempt from the MDL rules. We would respectfully request that this court grant the relators petitions for writ of mandamus and order that the trial court remand these cases back to Orange and Jefferson County. Thank you.
Any questions? Right, these original proceedings are now submitted. Thank you very much to all of you for your excellent advocacy. I think before we got on the bench, I had asked if you would be willing to stay. I forgot that our interns are at a different, these are 3 interns who are going to go with us to our post-op. Our interns have a competing oral argument with the 14th Court of Appeals, so I think that's where our crew is at right now. But I really appreciate your willingness to offer to stay. Thank you so much. We are now adjourned. Okay.